Pretrials are not cast on stone. Had the defense allowed the first pretrial to proceed, they would have realized that though their concerns were genuine, which I agree, their fears were unfounded. They created a situation and walked away from it. In criminal trials, it's neither the court, the defense, nor the prosecutor who are on trial. It's the accused who must be accorded the best of the facilities to prepare for the trial. I urge all parties in this trial to be candid enough. The accused have a right of appeal or revision or on any pronouncement of the court where they feel aggrieved, which avenues they would have followed. Arguments, responses, and agreements by parties to a criminal trial have implications on the quality of the pretrial and consequently the trial itself. I do not wish to dwell on the issue of pretrial conference except to add that it's in use through active case management guidelines, which were gazetted by the then Chief Justice, retired Dr. Mutunga, but was first rolled out in pilot court stations. It will eventually be adopted in all court stations and in all case types. Section 5.1 of the guidelines provides that in furthering the overriding objectives of the guidelines, the court shall set a pretrial conference date as soon as possible, preferably not more than 14 days after a plea of not guilty has been entered, determining the length of the trial, achieving certainty as to what must be done, by whom and when, in particular by the early setting of a timetable for the progress of the case. Monitoring the progress of the case and compliance with directions. Ensuring that evidence, whether disputed or not, shall be presented in the shortest and clearest way. Ensuring determinations of all aspects of the case necessary for expeditious trial. Encouraging the parties to cooperate in the progression of the case, and exploring the practicability of making use of technology. Providing an opportunity for consideration of plea bargaining and, where appropriate, alternative dispute resolution, and but not limited to alternative dispute resolution. And this is what is expected from all the parties concerned in this case on the 20th of June 2018. That is the ruling of the court.